Hi, my name's Matt Christensen. I am the managing partner here at Hansen Johnson. My practice is largely bankruptcy related matters, also deal with real estate and business transactions and other disputes. Today we're going to talk about a new type of bankruptcy that came into play here in 2020. Last year, Congress passed the statute that allowed the new type of bankruptcy. As many people know, there's several different chapters, Chapter 7, 11, 12, 13. Within Chapter 11, there's now a new type of bankruptcy specifically for small businesses. The issue was, historically, Chapter 11 has had small business provisions that apply to small businesses and allow them to file a Chapter 11, have a slightly streamlined process, but there were still many of the requirements of what I call a big Chapter 11 that were applicable to those small businesses and made it sufficiently hard for them to make it through a Chapter 11 process that several of the stakeholder parties urged Congress to create a new way for small businesses to thrive in Chapter 11. So the new small business provisions are found in Subchapter 5, Roman numeral 5, of Chapter 11 of the U.S. Bankruptcy Code. The Subchapter 5 provisions of Chapter 11 that apply to small businesses are making it easier to have a small business be successful in a Chapter 11 proceeding. The first question, of course, is who can qualify as a Subchapter 5 debtor. The Subchapter 5 is available to small businesses whose debts don't exceed a certain limit, and those debts are at least 50% debts related to operating a business. The debtor can be either a company or corporation, an individual, or a married couple. The debt limits originally were set at approximately $2.7 million, so if the business had more than that in debts, it would not qualify for Subchapter 5. With the CARES Act in March of 2020, Congress specifically raised those debt limits to $7.5 million, so if you're a small business with debts up to that amount, you will qualify for Subchapter 5. The increase in debt limit is set to expire at the end of March 2021. It was just a one-year increase. Here in Idaho, interestingly, about 50% of the Subchapter 5s that have been filed are individuals, not actual business entities that are filing. Some of those individuals are successfully proceeding through, some are struggling, but the same is true of the businesses that have filed as well. The cost savings really come from things that are normally required in a Chapter 11 case that are not required in a Subchapter 5 case. So for instance, in a big Chapter 11, you may have a creditors committee that gets appointed, and their job is to help monitor the case, propose plans, that sort of thing. In a Subchapter 5 case, there are no creditors committees. In a normal Chapter 11 case, there's a quarterly fee that has to be paid to the United States Trustee's office. In a Subchapter 5, there are no UST fees that have to be paid. The process of getting a Subchapter 5 plan proposed and approved and through the process is much more streamlined. It's essentially a single-step process now, where before it required at least 2 different hearings, potentially a valuation hearing, and so all of that just added cost and time to the process of getting your plan confirmed. The time frame for getting a plan confirmed in a Subchapter 5 is shortened up. The debtor must propose a plan within 90 days of filing the case and then work towards getting that plan approved. There can be amendments to the plan, but you have to at least start the process within 90 days of filing. There is also now a Subchapter 5 trustee that gets appointed in a Subchapter 5 case, and that appointment is automatic. In normal Chapter 11 cases, there are no trustees appointed unless the debtor does something they shouldn't be doing, in which case they may appoint a Chapter 11 trustee. So the Subchapter 5 trustee that gets appointed, the role of that trustee is to assist all of the parties to propose and work together to find a confirmable plan that can get confirmed and start the reorganization process of that debtor. The Subchapter 5 trustee gets paid by the bankruptcy estate for pre-confirmation work. It's essentially an hourly wage that the Subchapter 5 trustee gets paid. Post-confirmation, if the trustee is still involved at that point, will be either a flat fee or similar to like a contingency fee if they're distributing funds, there's a percentage that they would get paid. There's also modifications in Subchapter 5 for professionals that the debtor may hire. So an attorney or an accountant or an auctioneer or any of those sorts of individuals. Normally in a big Chapter 11 case, if those parties are still owed money from pre-petition work they did for the debtor, they would not qualify to be employed. The Subchapter 5 provisions provide that if that creditor is owed less than $10,000, that would not prohibit them from being employed under the employment provisions of the code. Lastly, the discharge. Most debtors file bankruptcy so they can get a discharge of their debts. In Subchapter 5, in a consensual plan, meaning one that there's no objections to, creditors are all on board, then the debtor will get a discharge immediately upon confirmation. In normal Chapter 11 cases, especially for individuals, they don't get a discharge until the plan payments are all made. So that's a big difference in Subchapter 5, where that discharge may come in as soon as the confirmation is entered and the parties can move forward. Obviously, there's some nuances to all of that. There's other differences between a big Chapter 11 and a Subchapter 5, but that at least gives you kind of a short look at what that new bankruptcy subchapter gives the small business debtor that wasn't there before. If there's more questions or you want to learn more about Subchapter 5 or any other type of bankruptcy, please get in touch. You can find us at our website, www.angstman.com. That's ANGSTMAN.com, or our phone number 208-384-8588.